Hello and welcome to today's webinar. I'm delighted to have you with us. We're going to focus today on questions related to Brexit and immigration. As many of you will know, the Brexit will be finalised at the end of this year, and that will bring to an end freedom of movement. And we've also seen recently a new immigration system introduced into the UK. And so today's session is really a chance for us to address some of the questions which we know many of you have in relation to those changes and how they affect UCU members across the UK. I'm really delighted to be joined by two experts from our Bindmans lawyers who provide us with immigration advice. So hello to Ashley and to Abigail, who are here to answer lots of your questions today. And thanks also to Seamus, who is going to be interpreting for us during this event. To kick off, I'm going to hand over to Ashley, who's going to make a few introductory remarks just about some of these changes and the impacts that they will have on members. And then we're going to come back and take a whole host of your questions. And so I'm just going to hand over to Ashley now, and then we'll go into the Q&A after some opening remarks. Thanks, Ashley.
Thanks very much, Jenny. So hi everyone, and thanks for joining us today. So Abigail and I are going to be talking about the upcoming changes to the immigration rules and how that will impact on UCU members. So everyone will be aware, I'm sure, that the transition period is coming to an end at the end of this month, and then there will be a grace period until the end of June, whereby European nationals resident in the UK at the end of the transition period will be able to make an application for pre-settled or settled status. We also have seen changes to the sponsorship rules, so that's currently for non-European nationals, and that will those changes came in on the 1st of December, and as of the 1st of January, those changes will impact on newly arriving European nationals as well. So today we're going to focus largely on European nationals because we had quite a lot of questions from the members to get through, and that is the most pressing deadline at the moment. And then we will hopefully be able to take any other questions that you have, time permitting. So I think Jenny will now start putting the questions into the chat, and we can get started.
Yeah, thanks, Ashley. That's really helpful. As you said, today we'll focus mostly on European issues. Obviously, I know that there may be a lot of members watching who aren't European nationals, and hopefully, we can cover a little bit of that, but maybe focus more on that in future events as well. So we'll think about this as the first of many. Yeah, I think if we move on to some of the questions which our members have submitted in advance, I think a good place to start is really just a bit of a summary of sorry, that's the wrong question, of some of the key changes that are going to impact on the status of European nationals who continue to work in the UK higher education sector and indeed further education after Brexit.
Yeah, I mean, I think the main change that everyone needs to become aware of is that European nationals as of the 1st of January will be subject to immigration control. So that's something with the end of free movement, European nationals will now need to have leave to enter or leave to remain in the United Kingdom, or have indefinite leave to remain. And the Home Office has been preparing for that with the introduction of the EU settlement scheme. So that is open for applications for limited leave to remain, which is pre-settled status, or indefinite leave to remain, which is settled status. So European nationals who are resident in the UK by the 31st of December will need to make one of these applications by the end of June 2021 in order to continue to live in the UK after Brexit or the end of the transition period. I think one thing is important to note is that although the 31st of December is the end of the transition period, it's not the deadline for your settled status application. So we have transitional regulations, which are being referred to as the grace period regulations, which basically mean anyone who is lawfully resident in the UK on the 31st of December under the regulations or the free movement regulations will continue to be considered lawful residence until the end of June. So basically giving them that additional 6 months, if needed, to make their settled status application. So that's people that are here. Everyone who isn't here and isn't resident in the UK will be considered a newly arriving European national, and they would have to look to apply under the sponsorship route, which is the skilled worker route.
Great, thank you. So yeah, some big changes there. And if we can sort of move on to another question, we had quite a few questions through about settled status and what the changes will be in relation to that. So one of the questions we had was, how will the right to work in the UK change for people with settled status, and will the worker registration scheme be back? Perhaps if I could come to you on that one, Abigail.
Yes, hi there. So for people who have got settled status, essentially what settled status means is that you have permanent residency here, which is also known as indefinite leave to remain. Effectively, you can stay here forever. You are free from immigration control. You have the right to work with both pre and settled status. Pre-settled status is what you get if you haven't been in the UK for 5 years. Once you've been here for 5 years, you get your settled status. So the pre-settled moves on into settled status quite smoothly. You have the right to work, which is your right to work. You're not tied to any employer or any institution. Just like now, as an EU national can change employer when they want to, it will be the same when they've got pre or settled status. There is nothing in the works about having anything akin to the worker registration scheme, at least as far as we've seen, and there have been huge amounts of guidance published already on the status of EU nationals. No mention of anything to do with the worker registration scheme. So I think people can be very confident that they're not going to be expected to do anything like that. The main thing that people must focus on is applying for their pre or their settled status within the relevant timeframes.
Great, thanks, Abigail. That's really helpful. And I think the sort of third area where we had some quite a few questions coming through was in relation to citizenship. Before I move on to that, I should just say it'd be really great if people do. We've had a number of questions submitted in advance, which we're going to try and cover a lot of today. But if people do have questions that they haven't submitted in advance and you wish to post in the comments, then we will try and accommodate some of those towards the end of this event. We know that there are lots of questions about these changes and how they impact different people in different ways. So please do feel free to post in the comments if you've got questions about how a lot of this is going to work. But yeah, if we can maybe just move on and touch a little bit on citizenship. Can you perhaps, Ashley, if you could run us through some of the questions, particularly related to how the ability to gain UK citizenship will change for EU citizens that entered the UK before Brexit and before the deadline at the end of the year?
Sure. So in terms of citizenship, nothing is really changing. So the requirements for citizenship are set out in the British Nationality Act. So they are separate to the European regulations that we've seen being amended. And some of the main criteria that focus on immigration status are that you're free from time restrictions on your stay when you apply, and that you've been lawfully resident in the UK for the qualifying period, which will be either 3 or 5 years, depending on whether the applicant's married to a British citizen or not. So to be free from time restrictions, someone will either have to have permanent residence or have indefinite leave to remain. And they'll also have to be lawfully resident in the UK. So that stays the same. So if you have settled status, you're free from time restrictions in the UK. Having settled status, however, is not the same as being lawfully resident, and that's just something to think about. Because when the Home Office will consider a citizenship application, they will look at that period of residence, the 5-year period. And so say, for example, someone was resident here under the regulations pre-Brexit, but actually was not a qualified person. So by that we mean they weren't a worker, or they weren't a student or self-sufficient, or perhaps they were self-sufficient but didn't have, or a student and didn't have sickness insurance. Now, the Home Office viewpoint at the moment is that that means that they would not have been lawfully resident for the purposes of the regulations, which could have an impact on the citizenship application in terms of good character, which takes into account immigration considerations or breaches of immigration law, or in terms of just general lawful residence. So evidence of the quality of the person's residence should really be provided with any citizenship application. But that doesn't mean to say you wouldn't qualify for settled status, because they're two very different things. Settled status looks at actual physical presence in the UK rather than having to be a qualified person, which permanent residents did under the regulations. So I think the main thing to do is to basically focus on making sure you have settled status when you come to apply. You've got your indefinite leave to remain, essentially, and then look back at the 5 years prior to the date you make the application and understand what your status was at that time. Obviously, if you already have a permanent residence document from the Home Office have already assessed that you were lawfully resident during that 5-year period, so that will obviously be helpful with the application. But the sort of basic point is that the requirements are still the same now as they will be in January.
Perhaps, if you don't mind, Ash, I could just add in here that there are some specific issues that German nationals face, because Germany has decided that it will not allow its citizens to become dual British and German nationals after the 31st of December. So any German national who wants to hold British citizenship needs to put their application in before the 31st. So you've really got a short space of time to get it in. I have written a blog about this, which is on the Bindmans website, and perhaps also Jenny may be able to circulate, which is probably worth having a look at if that's something you're concerned about. And that also summarises some of the issues about whether or not you were lawfully resident in the UK before you obtained your pre or settled status.
And just another follow-up point on that is that you don't need to become British, but this remains your choice. Brexit doesn't force your hand, essentially, unless you actually want to become British, because the settled status scheme allows you to preserve the rights of residence that you currently have under free movement. And so you can do that, and you can lock in your settled status if you've had 5 years residence, or you get your pre-settled that will allow you to work towards settled status. So you could effectively have pre-settled status forever and not take that next step. It's purely a matter of personal choice, what your individual circumstances are, and obviously also if your own national authority permits dual nationality.
Thank you. Yeah, so I think lots to unpack there, and in relation to sort of the longer term changes for people who don't have British passports, obviously that's a lot of that applies there as well. We've had a couple of questions, and I think somebody's asked in the chat as well about people who wish to live in the EU and work in the UK, and perhaps a little bit of the question vice versa as well. Could you perhaps say a little bit about that? Abigail, I wonder if you maybe come in on that question.
Yeah, sure. So the government has thought about this to an extent. They define these people, they label them as frontier workers. So you're a frontier worker if you're an EU national, you live outside of the UK and you work in the UK. Your work can be as someone who is employed or self-employed. Also, in some circumstances, if you've got retained rights, I'm not going to go into full detail about retained rights. It's a bit complicated, but it really covers people who have been unable to work because of an accident, or they're on maternity leave or paternity leave, those sorts of things. There are some quite specific definitions about whether you can be considered to be primarily resident in the UK or outside of the UK, you're considered not primarily resident in the UK if you've been in the UK for less than 180 days, so that's 6 months, in the last 12 months, or that you have returned to your country of residence at least once in the last 6 months or twice in the last 12 months. So you can see that you can spend quite a substantial amount of time in the UK, but still be considered to be someone who lives outside of the UK in another EU country and therefore are a frontier worker. You have to, because of the end of the transitional period on the 31st of December, if you want to be considered as a frontier worker, you need to show that you have already been working in the UK prior to the 1st of January 2021. If you can show that, then you can continue to travel in and out of the UK without obtaining any sort of additional visa or permit up until the 30th of June 2021. But from then, if you want to come into the UK as a frontier worker, you will have to apply for a frontier worker permit, which is an application that you make online. The scheme is open, so you can make it now. It's free. You don't have to be in the UK to make it. And what we're saying to people is there's no transitional arrangements about travelling in and out, whether you've applied but you haven't had your application decided. As of the 1st of July 2021, if you don't have your permit in place, you won't be able to come into the UK as a frontier worker. So really don't leave it until the last minute if this applies to you, because you might suddenly find that you've run out of time and you haven't got your permit in place. It's also important to know that, I mean, a lot of people travelling here to work will have family members living in their EU country. Your family members are not going to be dependent on that frontier worker permit. They will have to apply for their own leave, depending on what their situation is or what they're coming to the UK for. A lot of people will be asking about whether or not the primary residency is affected by this pandemic. There is some guidance on this, but it is quite complicated. And again, I'm afraid it's going to be too in-depth for the purposes of this webinar. But there is some guidance available on that.
Thanks, Abigail. That's really helpful. And just in terms of, you mentioned that people need to provide evidence of the fact that they've been working in the UK. Could you talk a little bit just about the sort of types of evidence that you're talking about there? Is that possible?
So it will be, I mean, the very obvious employment contracts, or if you're self-employed, then invoices, or anything to show that you've achieved some work in the UK, and that you can show your travel tickets to show that you've been traveling in and out for work, letters from your clients, all that sort of evidence can be submitted to show that you're working here. If you've got retained rights, then you will have some sort of agreement either with your employer, or if you are paying taxes or reducing taxes paid, there'll be a paper trail about it. So it's what you might expect. There's no tricks to the evidence that you need to provide. It will be fairly obvious things. If you're genuinely employed in the UK, you will have documentary evidence to prove it.
Great, thank you. I know it sort of seems obvious, but when you're trying to sort of navigate the vagaries of the Home Office, it's always good to be clear. So thank you for that. That's really helpful.
And I would say, oh, sorry to interrupt. I think, they want people to be able to apply for these permits. It's a friendly application to make, so people shouldn't be too worried about it. And also the other thing to remember is that the application is free. So if you try once and don't succeed, just try again and get better evidence together.
Okay, thank you. If I could sort of move us on then to the next question. We've had a question through about having applied for the EU settlement scheme some time ago, clearly this has been open for a little while now, but there's been quite a lot has changed in the intervening period. So would you be able to provide a little bit of clarity around whether people need to do anything else if they've already sort of applied for the scheme a while ago, in light of all the changes, or if applications that were made, a year or two ago will still be valid?
I think I'm going to answer that one. Absolutely, it will be valid. As long as you've had confirmation through, you will have had an email through confirming that you've got your settled status. That doesn't expire, that doesn't change. Make sure that you do absolutely have something in writing in your inbox saying that your application has been successful, and that should also give you a way to for you, and then in the future for employers, to check online that you have your settled status, and therefore your right to work continues even after the end of the transitional period, and then the end of the deadline to apply for settled status on the 30th of June 2021. If you've got any doubts about whether you've got your settled status, then probably the best thing to do is contact what's called the EU Resolution Centre, which is a helpline for people with questions about the EU settled status. They can go through and check their own records, provided you can give them your basic personal details and the passport number that you use to apply, or the national ID number that you use to apply for your settled status. But you can be confident that the settled status is not going to be taken away. The only way you would lose your settled status is if you've been absent from the UK continuously for 5 years, at which point your status lapsed. But obviously the scheme's not been around for 5 years yet, so no one's going to be in that position.
Yeah, that's really helpful. Thanks, thanks, Abigail. And I guess sort of following on from that, I wonder, Ashley, if you might be able to say a little bit about this, about how employers will check for settled status, and what the burden of evidence or proof is, on people who hold it to provide.
Yeah, so at the moment, I think nothing changes actually until January. But say from between January and June, and you're in this sort of limbo period, as it were, where you're allowed to be here, but you don't have to have made your application yet, technically. During that period, the right to work checks that an employer will carry out are not changing. So the Home Office has come out and said, look, employers cannot ask you for proof of your settled status, okay? They've got to continue to treat an EU national as they would do now. So if you were to provide your passport to your employer, then that should suffice. They shouldn't be asking for anything further. After the end of June, then they will have to carry out further checks, because they need to be sure that you have got the ongoing right to work. And you can actually do this now as well. So you can go online to the Home Office's website, and you can check your own status, and you can get something called a share code. And this will be a code that you can then provide to your employer, and then they will use that together with your passport number or your national ID card, whatever ID you've used when getting your status, and they will put your personal details into the Home Office employer checking service, and then that will come back and give a positive or a negative verification to say that you have or you have not got the right to work. So that will be then your employer's fail-safe option. They will do that. They will keep a copy of that record on file, and that then provides them with a statutory excuse against any allegations of employing someone illegally.
Okay, that's really helpful and a really useful summary. Thank you. We've had a couple of quite specific questions about other sort of rights in particular in different sort of scenarios for people who apply for settled status, or whose sort of immigration rights are changing as a result of Brexit. So if we could maybe just move on to a couple of those, that would be helpful. First of all, we had one through that asked about rights after retirement, if the person chooses to stay following Brexit. So I wonder, Ashley, if you could maybe say a little bit about that.
Sure. So in terms of your status, it wouldn't really change. So basically, with settled status or pre-settled status, the main requirement is your residence in the UK. So it's about being here, being a resident. It's not about the nature or the quality of your residence. So it's different in that respect to acquiring permanent residence under the free movement regulations, where you would have to have shown that you were a qualified person, so that you were working or you were self-employed or self-sufficient, that kind of thing. So once you retire, so actually before you retire, if you have pre-settled status, that doesn't change after you retire. So you still have pre-settled status because that was granted to you on the basis of your residence in the UK. So you can continue to stay in the UK after retirement without doing anything else, making sure that if you haven't reached settled status, that at some point in the future, when you hit that 5-year mark, you apply for your settled status before your 5-year limited leave to remain with pre-settled status expires. So becoming retired and no longer having an income doesn't have an impact on your immigration status.
Great, thank you. And sort of similarly, questions about whether people, if they change job or if they lose their job, during a period of, after they've achieved settled status, what will people's rights be in that sort of scenario? Obviously, we know that with sponsored visas, there are implications if, someone were to lose their job, but it'd be really helpful to understand a bit more about how that would apply for people with settled or pre-settled status.
Yeah, I mean, it's the same really is the answer to the retirement question. So again, your status isn't tied to your employment. Okay, so it's not dependent on you having a job in the UK. It's just dependent on you having limited leave. So you wouldn't lose the right to be here, either pre-settled or settled status, if you were to lose your employment in the UK and had a gap whilst you looked for work. Similarly, well, actually, just to point out, the way you would lose your status is through your absence or by committing some sort of offence or having lied and used deception to get the status in the first place. So retirement or loss of work or employment is not a reason to lose your status.
Great, that's very helpful to know, and hopefully will provide a bit of reassurance for people as we're sort of thinking through the implications. Quite a common question that we've had is around travel implications for those with settled status. So what could, perhaps, Abigail, would you be able to speak a little bit about the travel implications from the 1st of January for those who do have settled status?
Yeah, so all EU nationals can continue to come into the UK using their national ID card or their passport, whether or not they've applied for pre or settled status between the dates of 31st of December 2020 and the 30th of June 2021. So travelling in and out doesn't really change. What we would say to people is that if they are coming into the UK during that period, to try not to use the e-gates, but to go through immigration control. This is to avoid you being stamped in as a visitor when in fact you're not a visitor to the UK. You're an EU national with the right to apply for pre or settled status up until the 30th of June. You must have made your application for pre or settled status by the 30th of June 2021. Otherwise, you are going to have to apply for some sort of visa to come into the UK if you're planning to study or work here. You'll still be able to come in without applying for a visa if you're coming in for a holiday, so less than 6 months. Holiday makers can't switch into another visa category and can't work and can't study here unless it's a very short course. But you will be able to come in for a holiday. The Home Office have also introduced another deadline, which is the 1st of October 2021. From that date, you will not be able to enter the UK using a national ID card unless you've got your pre or settled status, or you've got a family permit as a family member of an EU person with pre or settled status here, or you've got your frontier worker permit, which I've discussed earlier, or you're something called an S2 healthcare visitor. So that's going to be quite a specific group of individuals. And again, if you're a Swiss service provider, so again, that's a specific set of individuals. If you're coming into the UK after the 1st of October 2021, you'll show your passport and the immigration officer will check to see whether you've got pre or settled status. So it will be pretty similar to what happens now. They'll have a look and they'll just check their own electronic records, make sure that you've got their status. Everything's online now. So, provided you meet those deadlines, you should be all right. That once you've got your pre or settled status, then your actual experience at port is not going to change really at all.
Great. It's good to know, and again, hopefully quite reassuring to know for a lot of our members. I mean, in relation to absence and travel, we did have a question from Carrie-Anne, who was able to say, was asking if it might be possible to elaborate a little bit on the rules of absence about people, because obviously we've got a lot of members who do research and a lot of that takes place abroad, and we know that there are limits on the amount of time that people are able to spend out of the UK. And I wondered if it might be possible to say a little bit about whether research is included in those or not, or whether we just don't know at this point.
My view is that it's not particularly clear. So the rules are that you can be away for 6 months in any 12-month period without breaking your continuity of residence. Okay. Now, continuity of residence is important when working towards settled status. So if you have more than 6 months in any 12-month period during your 5-year qualifying period for settled status, you wouldn't qualify for settled status. Okay, so you would then, if you were away for 7 months, then you would have to start the 5 years on return. However, if you're away between 6 to 12 months, if you're away for more than 6 months, you wouldn't lose your pre-settled status. So there's two different sort of absences requirements. So there's the continuity of residence, which impacts on your ability to apply for settled status. But then there is what makes you lose your pre-settled status or makes it lapse. And so your pre-settled status, once granted, will only become invalid if you've been away for more than 2 years. Okay. Now, the difficulty with that is that if you're away for more than 6 months but less than 2 years, is that when you return, what you have left is whatever you have left on your limited leave to remain for pre-settled status. So you wouldn't be able to get to the 5 years. And there's been quite a lot of discussion about this amongst practitioners, but I think at this stage, my view, and I think the general view, is that you can't then apply to extend your pre-settled status, because there was a requirement for continuity of residence to be eligible in the first place, which you would have broken by being away. There's nothing in the guidance that says, like it does in Tier 2, that research purposes basically can be excluded from that. What we do have is that you're allowed one single absence of up to 12 months for an important reason. And one of those reasons is vocational training or an overseas posting. Now, it's not clear whether that would include research or for example, a sabbatical, which maybe you would choose to do rather than it being a requirement of your job to do. So I think my view is that it's not clear, unhelpfully.
Yeah, no, I think that's sort of consistent with a lot of the experiences we've seen in recent years as well, where it's not been terribly clear. So I think that's definitely something which UCU can continue to push on and push for clarity on as we move forward as well, because clearly it's an issue which affects a lot of our members. I wonder, maybe Abigail, if you might be able to just say a little bit more in general terms about, because obviously alongside the Brexit rules, we've had this new points-based immigration system brought in, and tier 2 visas are shifting to become skilled worker visas. I wonder, could you maybe just say a little bit about some of the key changes and sort of things that have changed between those? I know that there's not loads that's terribly different, but it'd be just really helpful if it might be to sort of speak a little bit about the general summary of how that's changed.
Sure, yeah. So skilled worker replaces tier 2 really as of now. So anybody that's looking to come to the UK to take up a job offer in the future will be coming in as a skilled worker rather than as a tier 2 migrant. What the government has tried to do with the skilled worker route is make it a bit easier for people to come in to work here, with the awareness that because the skilled worker scheme will now apply to EU nationals who want to come in, who have not got their pre or settled status by, or not living here by the 30th of December, or have not applied for their pre or settled status by the 30th of June. So the application is similar in that you still have to have a job offer from a licensed sponsor in the UK. So because the scheme now extends to EU nationals, employers who previously just hired EU nationals without really thinking about it, if they want to hire new EU nationals in the future, they will have to have applied for a sponsor license, before they can employ any EU national or other national. The job offer has to be a genuine job offer. One thing that has been taken away under the skilled worker scheme is the resident labour market test. Some people may be familiar with that, which essentially means that an employer has to prove that there was no settled person or EU national who could do the job that they wanted to employ the individual for. That's gone out the window, which will make it easier for employers to employ EU nationals and other nationals, though they still are expected to prove that they've got a genuine job offer. So showing the job description, that there's an actual need within the organisation for that job, etc. Another big change is that they call it the skilled worker route, but actually it's a lower skill level than was previously under tier 2. So under tier 2, you had to essentially have a degree or be skilled up to degree level. Under the skilled worker scheme, you have to be skilled up to the level of having your A level in a job. So it's a slightly lower skills test for people coming in. You will still have to be given a certificate of sponsorship. That hasn't really changed, but there will be more certificates of sponsorship available. The quotas and caps that applied under tier 2 have been suspended. They may be brought in later on if the Home Office decides that there are too many people coming in as skilled workers, but at the moment there's no cap, there's no annual cap or monthly cap, so that's helpful. Individuals will still have to have be able to speak English to a minimum degree, and also excuse me, the job itself will have to meet a standard occupation code, and standard occupation codes are set out in an appendix to the immigration rules, so both an applicant and their potential employer can check that they've got the right standard occupation code. They also have to meet a minimum salary threshold. The absolute minimum below which you cannot go is 20,480, I think, something like that, off the top of my head, about 20,000, just over. But there are also other minimum salary thresholds, depending on the type of job that you're doing, whether you're coming in as a graduate trainee or as a experienced person or someone new to the route. So there are certain calculations that will still have to be made for both the employer and a person applying under the skilled worker visa. It is easier than tier 2, but it's not a total doddle. There's still certain things that have to be checked, I think, is what to take away. But the best things about it are that the skill level is lower and that you don't have to meet the resident labour market test.
Yeah, I think those certainly the getting rid of the resident labour market test is a positive development. I think that the hurdles are still high and still present for a lot of our members. But I think that and as Alison Fiddler has just pointed out in the comments, the thresholds for going rates are still very high, and UCU has raised a number of concerns about those minimum salary thresholds, particularly for some of our art staff, who perhaps in professional support roles, where those thresholds do feel very, very high still, and we will continue to push on that as we go forward. One of the other things which I think it's worth mentioning is, there have been a few little tweaks to the scheme. So those on the skilled workers visas, for example, the financial requirement has slightly changed. It's slightly increased in terms of what used to be in terms of the maintenance requirement. It's gone up by a few £100 from 945 to 1270. So it is really worth having a check of kind of some of those little details, because we don't want any of our members to be caught out by those as they carry on. But in general, as Abigail says, I think that some of the changes have been quite positive, which is good. That's really helpful. Thanks, Abigail. If we could move on to, we've had a question through from Rick Campion, who's asking that, as a Republic of Ireland national, I was told I didn't need to apply for settled status due to freedom of movement legislation that is currently in place. Obviously, we know that the relationship between Ireland and the UK is slightly different. As someone who comes from Northern Ireland, right in the middle of it all, I'm acutely aware of that. And so I wonder, Ashley, might you be able to say a little bit about that?
Yeah, so what you were told, Rick, is right. So you don't need to apply. So the rights of Irish citizens in the UK, although you have got free movement rights because you're a European national, in the UK your rights are derived from other legislation. So you're part of the common travel area. So it's not reliant on your free movement rights for you to be resident here. So you don't have to apply for settled or pre-settled status. You can do if you want to. There's nothing to prevent you from applying, but there's no requirement. So, waking up on the 1st of July and you've not made an application, you will still be lawfully resident here.
Great, thank you. I think we've if I can just encourage people who are watching live, if you've got some further questions, please do keep asking them. We will try and cover as much ground as possible. One of the questions that we've had through, we had a couple of similar ones in advance, is in relation to EU nationals and student fees. And obviously, as a higher education and further education union, we are very concerned about the changes that as they apply to students as well as to staff. Some of this, is still to be determined. For example, we know that the status of the Erasmus Plus scheme and the UK's access to that is still not confirmed. That is part of the ongoing negotiations, and we unfortunately don't have an answer on that as yet. But as it relates to tuition fees, we know that there's also quite a complicated picture across the UK, and the sort of the rules and regulations are going to vary a little bit depending on where you are in the UK. I'll ask Ashley and Abigail if they do wish to say anything on this, but before I do, I think one of the useful resources is UK CISA, the website, which is the sort of International Students Association, where there's quite a lot of useful information. So I'll post a link to that in the comments. But Ashley or Abigail, do you have anything you want to say on students? I know it's sort of it's a bit of a tricky area because it does vary so much.
Yeah, I think that's the thing as well. It varies between the devolved administrations as to what is required for you to be classed as a home fee student or not. So I think I would just echo what Jenny says in terms of checking out the UKISA website. It really has lots of resources on there in terms of what you need to consider. It breaks it down into the different years when you might have started your studies. So the general rule of thumb, my understanding, is that as long as you've started your studies already, you're not affected. And then some people starting in 2021, there's already some guidance out there. So I think you need to look at your particular circumstances and just compare it to the guidance that's out.
Yeah, that's right. We did have a question about 2021-22 fees for people who have attained settled status in the UK. To confirm that home fees will still apply for people who have settled status in England, but because it does vary so much across the devolved administrations, I think it's really best to explore that further and really consult that UKCISA website for more information on that. If I could maybe just come back to a couple of the other questions that we had through in advance, Ashley and Abigail.
Yep.
One of the questions, question 12 that we had was about the workplace implications and sort of documents that needed to be provided to employers. I think you sort of said a little bit about this earlier, but I just wondered if we could just revisit that, because I think it is the sort of thing that's really important for people to understand. So if what are the workplace implications for people with settled status? Perhaps if I could come to you, Abigail, on that one.
Sure. So I think the important thing to remember is if you've got your settled status and pre-settled status as well, then you're in a really good position. Okay, you're permanently in the UK. You're free from time restrictions. Your status is not tied to your employment. Up until the 30th of June 2021, an employer can't actually ask you to prove your right to work in the UK as an EU national. They can only ask to verify your identity and your nationality. I think Ash has covered this to a certain extent, which creates a slight disparity for for employers who can't ask people, but are also worried about whether they may be employing someone who hasn't got the right status here. But in terms of the individual, your settled status, it's not tied to your employment. You can work for anybody you want to. You can change jobs at will. From the 1st of July 2021, the employers will have the right to check your status. And so they will want to see, as always, your passport or your national ID card. And they will also, I suspect most employers will want your right to work share code, which is something you can obtain online. You then provide it to your employer and they also do an online check. And all that does is confirm whether you've got your pre or settled status. And as long as you've got your pre or your settled status, you can work here. And your employer checking that and taking a copy of your passport or your ID card is sufficient to show that they have done the right to work checks that they're required to do.
That's great, thank you. And I think sort of following up on that then, if it's possible just to say maybe a little bit, Ashley, about just to reinforce the changes that will be implemented after Brexit with regards to indefinite leave to remain. As I say, I know that we've kind of covered this, but I think it's really useful to use this session just to reinforce those key changes.
Okay, so indefinite leave to remain, if someone wants to apply for indefinite leave to remain as European national, then the application they will most likely be applying for is for settled status under the EU settlement scheme. So that application can be made today, it can be made in January, it can be made any day up until the end of June next year. And the requirements are you being able to show that you have been continuously resident in the UK for the past 5 years. And the application will be done online. You can verify your ID using an app, the EU Exit ID document check app, and the Home Office will carry out automatic checks. So if you have been living and working here for a university, you'll give them your national insurance number as part of the process, and the automatic then you're invited to provide additional documentation to prove your residence. So you might want to provide letter from your employer, your P60s, proof of your address over that 5-year period, and then you will be granted settled status. If there's any concerns by the Home Office that you haven't been here for the 5 years, you would be given pre-settled status, which they will tell you what they think they're going to do, and so you can say, no, I don't want to accept that. I want you to look at me further for settled status. Or if that's what you're given, you've got 5 years limited leave to remain, and you can apply again for settled status at any point in the future before the end of that 5-year period, either straight away, for example, if you thought it was just simply wrong and you wanted them to look at it again, or maybe you did have a period maybe towards the start of your 5 years that you weren't here, or you didn't have the evidence, then you would wait until 5 years from the end of that initial break period to apply again.
Great. So yeah, so I think it's to be reinforced, isn't it, that if it comes back sort of negative or there are questions first time, just don't be put off reapplying. That it's really important that people keep engaging with the process as things go forward.
Yeah.
That's really helpful. Thanks. And then I guess maybe one sort of final question, if just relation to the permanent residence procedures, because I know a lot of our members obviously who have been working in the UK for some time and want to consider about permanent residence and British nationality. Can you just recap on how those are changing or not as things go forward?
That just sort of reminds me of something that we haven't touched on. So there might be members out there who have acquired permanent residence. So this is under the free movement requirement. So you've already done your 5 years. It could have been, 5 years ago, it could have been whenever. And you might have applied for a document to certify your permanent residence from the Home Office, which will likely be a blue card that you have. Just because you've got that doesn't mean to say you don't have to apply for settled status. That's a really important thing to know, okay? So your permanent residence is not sufficient by the end of June to keep you lawfully resident here. You will have to essentially upgrade your status and make the settled status application, which should be a really quick and easy thing to do, because you will say, I've got a permanent residence document, and they will have a record of that, so it should be fine. Then it'll just be a question of making sure that you've not been away for more than 5 years since you got that permanent residence document. So don't think you're safe just because you have that. You need to make sure you're under the EUSS scheme to be safe, or have already become British, okay? And then the other thing is, once you've got your settled status, is that if you want to apply for citizenship, then you can do that, provided you meet the requirements as we talked about earlier, which are largely no time restrictions on your stay, lawfully resident for 5 years. There are absence requirements, which are generally no more than 450 days in the past 5 years and 90 days in the 12 months before you apply. You need to meet an English language requirement and life in the UK test requirement. You need to be of good character. And intend to make the UK your main home. So those requirements have stayed the same regardless of Brexit.
Maybe I don't want to confuse people, but the language is a little bit confusing. So you've got your settled status, you've got your permanent residence, you've got indefinite leave to remain. So as Ash said, if you've got permanent residence, that is a permanent residence acquired under EU law. That's not under the UK immigration rules. Once you've applied for settled status, you've made an application under the UK immigration rules, which are the only things that are going to apply from once Brexit happens, apart from some certain retrospective things, which we can't get into here. If you've got indefinite leave to remain, that again is a grant of leave that you will have received under the UK immigration rules. There are some, I've been contacted by quite a few academics who have been here since the 70s, before the European Union, and they will have been given a stamp in their passport or possibly a letter from the Home Office saying you've got indefinite leave to remain. If you've got one of those, then you don't have to apply for pre or settled status. So permanent residency, you do. Indefinite leave to remain, you don't. But for people who do have their indefinite leave to remain, it's probably a very old document. And so you might want to apply for settled status just so that you've got something more up to date. As Ash said, it's a question of making an application through an app that you can download onto your smartphone, and it is free to do. So if you're concerned that your bit of paper is really quite old and quite fragile, then it's probably worth making the settled status application.
Thanks, Abigail. And we've had a couple of questions through just while you're speaking with regards to that issue around sort of stamps and passports and things. So one from asking about whether settled status automatically transfers to a new EU passport. I don't know if that's something that you're able to say anything about.
So once you've got your EU settled status, it's your responsibility to keep your details up to date. So you will need to update your passport details online with the Home Office. And when you make the application, actually, you get an email to say, complete your details. There's also another link usually at the bottom of the email to say update your details. So just make sure you keep them up to date, because your status is linked to the passport that you would have used. So you need to update it.
Okay, so yeah, so a bit of manual work for members to do as things progress and new passports are issued. And then just coming back to a point you said earlier, Abigail, we've had a question from Francisco asking about EU nationals and using e-gates. I know you mentioned this earlier, but if you could just repeat your sort of advice in relation to that, in relation to coming in and out of the UK after Brexit.
So we would suggest that people don't use e-gates up until the 30th of June 2021. I mean, if it happens, I don't think it's the end of the world, but we just think you don't want to look like you're coming in as a visitor. You want to look like you're coming in as an EU national, either with the right to do so because you haven't hit the deadline of 30th of June 2021, or because you've already got your pre or settled status and you're coming in with pre or settled status, which gives you the right to work, to study, etc., rather than coming in and being marked as a visitor where there are significant restrictions on what a visitor can or can't do. Now, technically, even if you come in as a visitor and have your pre or settled status, you'll still have your rights to do things as a person with pre or settled status. You won't suddenly have turned into a visitor. But just to avoid confusion, if anything did come up or you were stopped because of customs or anything, you want to be clear that, no, I'm not a visitor. I'm coming in as an EU national with pre or settled status. So if you remember, try not to use the e-gates, I think is the main thing.
That's great. Thank you. That's really helpful. I think that we are sort of coming to the end of the session. So one thing it would be really helpful just to do a quick reminder of are key deadlines. Obviously, we know that there are a few different ones that have been mentioned throughout the session. The first of which is coming at the end of this month when freedom of movement comes to an end. But could you just sort of summarise the key deadlines that people need to be aware of in 2021 as it applies to some of the things we've been talking about today?
So I think I hope everyone has taken away the main deadline, which is the 30th of June 2021. You must get your application for pre or settled status in by that date. It doesn't have to be decided by that date, but you must have made the application, and that goes for your family members as well. Okay, so put it in a big red felt tip pen on your calendar, or set up loads of alerts on your phone, whatever it is you need to do. But 30th of June, sorry?
Just do it now, don't wait.
Yeah, to get your application in now. There's no reason not to. As we've said, if the application is rejected for any reason, you just try again, and if you keep getting rejected, you might want to seek legal advice. But, the process is relatively straightforward, provided you're an EU national and you're in the UK. The date of 1st of October 2021, I don't think people need to worry about that too much. It's really just from that date. You're not going to be able to come in with an ID card. You'll still be able to come in with a passport. It's just that the UK government hates national ID cards. You'll note that British citizens don't have them. They think they're really unsafe. and they want to try and put a stop to people coming in with them. But if you've got your pre or settled status, you can still travel in with your ID card. So don't get distracted by the 1st of October. The real key deadlines are 31st of December this year, so in about 2 weeks' time, and the 30th of June.
Just
That's
on the
great.
31st of December point, just to be clear, guys, you need to be resident in the UK by the 31st of December to be eligible to apply under the scheme.
Yeah, that's a really important point to finish on. Thank you, Ashley. And thank you to both of you. We've covered a huge amount of ground there, and I really hope that it's been helpful to everyone watching. If I could just sort of round off the session with a couple of pointers in terms of further advice that UCU is able to provide. Firstly, we've got a range of FAQs on this page, which I'll also post a link to into the comments. But Ashley and Abigail and colleagues at Bindmans have provided us with a really sort of helpful summary of some of the frequently asked questions in relation to these changes, and you can find them on this webpage. And if you are experiencing issues and have further concerns about about your applications and how your employment status will be impacted in relation to your immigration status, then please do get in touch with UCU's legal services team. We are keen to provide our members with as much support as we can, and obviously we will do as much as we possibly can to help anyone experiencing issues in relation to immigration. So I just want to say thank you again to Ashley and Abigail for their time. We will continue to update our webpage for our members as things go on. And I mean, I think what I should finish off by saying that we've really tried today to cover the key things that will help our members to protect themselves. That not to say that we think that lots of this shouldn't be different, but that this is how it is at the moment, and what you need to do to sort of make sure that you have access to the rights that you're entitled to, as people living in the UK and EU nationals who have that relationship with the UK. So, we will continue to campaign for a much more progressive immigration system in the future. And, the Migrant Members Standing Committee is hard at work addressing many of the inequalities that our migrant members face, both EEA nationals and non-EEA nationals, and so we will continue that work. But right now, and for the purposes of this session, it's just about making sure that we protect our members as much as possible. So hopefully it's been useful. Thanks again to Ashley and Abigail, and hopefully we can do this again in the future. All right, thanks very much, everyone. Take care. Thanks.